this, but if we have a look at the system of conformity and remedies in the CSG, there is, I think, an agreement that it is easier to understand and to apply that the complicated system that domestic law provides for parties involved in international trade. On the one hand, you have the civil law tradition that historically has divided or yes, I would say that divided the type of remedies available for the parties or the type of non-conformity available or that can occur for the parties depending on whether, for example, it is a hidden defect, whether it is a breach of a statutory warranty like the redivitory warranty or quantum minoris action, or whether there is an ordinary breach of contract, right? And depending on whether or where you fit the type of non-conformity in your contract, you may access and you may access different remedies, but also you are subject to different limitation periods. In most, that would happen, for example, in most Latin American countries. So that's something you have to bear in mind. China, for example, has departed from this system to a more CSG approach. That is true. But still, you will find the complications that Professor Spencer already mentioned, language barriers. On the other hand, you have the common law system with this distinction between conditions and guarantees, whether they are implied guarantees or express guarantees. And it's not always easy to understand to many lawyers from the civil law legal system, what does that really means, right? So the CSG doesn't share any of those two approaches that are approaches that work perhaps for domestic sales and that were conceived many years ago, centuries ago, for that purpose. But the CSG has a unitary approach, is called, where every breach will give you access to all remedies. The only distinction is made between the gravity, the importance of the breach, to access to important remedies like the avoidance of the contract or the replacement, complete replacement of the goods. So I think in that regard, the CSG is very convenient, is easier and more appropriate for international trade. And I think I will stop here, Cesar. I have more things to say, so maybe they will come up with the discussion.
Thank you, Edgardo. That was a very quick but very comprehensive picture that you drew, and it's a very interesting background for us to discuss. And I'd like to now invite Renata to make her initial comments, and I believe she will focus more on the Latin America, Brazilian situation. And so, Renata, please, you have the floor.
Thank you, Cesar. I'll just ask, can you see my presentation? Okay, so good morning for you all, and good evening and good afternoon for those in Europe and Asia, and good morning actually to Edgardo, who should be sleeping by now. It's a pleasure being here, and I thank Cesar for your kind invitation. And as Cesar has asked me, I will try to give you some general panorama of how, of the Brazilian perspective on the two topics of our meeting today, which are applicable law and place of arbitrations, for arbitration or litigation. These two clauses are usually called midnight clauses because they're usually left for the last minute of negotiation, meaning that in many cases they're not negotiated at all. In my brief presentation, I will address how to avoid these two midnight clauses becoming a nightmare in Brazil. And I will start with some words on applicable law. As you know, all international traders usually come from different cultures, and therefore as players search for certainty, foreseeability, agility, and efficiency. That means parties usually can achieve these 4 elements by choosing the applicable law. But the choice of applicable law has an ex-ante cost that parties may not be willing to make. In order to make a safe choice of law, one should ask which law to choose and if it is possible to choose this law. As for the first question, a comparison between Brazilian Civil Code and CISG, I could say that there is a huge difference between these two systems, because CISG leads with only one contract or mixed contracts that have a link with sales law. And therefore, it has a system of remedies, as Professor Edgardo has just explained, that is built to suit and that was built to international trade. If one take a look at Brazilian Civil Code, however, one will find that the Brazilian Civil Code has only general rules on breach of obligations and not even breach of contracts. And therefore, the specific set of rules is not, there's not a specific set of rules for sales contracts and for international contracts. However, the second question in Brazil is even more important, because to make a long story, a short story, the majority of Brazilian scholars understand that Brazilian private international law, there's a typo there, does not allow party autonomy on choosing the applicable law. This is, however, allowed when parties have agreed on an arbitration clause, and Professor Ingeborg has already pointed that situation earlier in her speech. It is true that when CISG entered into force in Brazil in 2014, it has put a new light under this topic, but to be conservative, one shall not rely on the validity of choice of law in Brazil. These specifics and peculiarities of Brazilian law, one will find also in other jurisdictions, and maybe that's a reason why, and that justifies why players usually do not negotiate applicable law, because it's very costly to understand and to get to know a legal system, yeah, and that may be a problem later when litigation or arbitration comes. And as Brazil, being a place of arbitration and of a jurisdiction chosen by the parties, I would not enter in this discussion, since Sherling will lead us in this further, but just to point out some 3 questions that are usually made and that have to be made by players is if the jurisdiction apply foreign law, and that would be yes in Brazil. If it is an arbitration-friendly jurisdiction, I would say yes for Brazil as well. And how may one enforce international awards and interim measures? I would say Brazil is a part of the New York Convention. And as for interim measures, we are not that friendly, but yes, we also apply interim measures, but that takes sometimes a long path. But as for CISG is in Brazil, is in force in Brazil since 2014. It is not an exotic animal in Brazil, and thanks to Cesar initiatives, as well as Professor Schwenze and Professor Edgardo, who have been in Brazil sometimes. Brazilian scholars, attorneys, arbitrators, and judges are day by day getting more familiar with the CISG, which is, of course, good news. And that is all for now. I would say obrigada in Portuguese. Thank you.
Thank you, Renata. And yeah, it was a joint effort starting in the early 2010s, mostly, that led to Brazil joining the CISG in 2013, and the CISG coming into force in Brazil in the following year, 2014. Brazil, I believe, very rapidly produced, and Renata was one of the authors, Professor Schwenze, Edgardo, they were all part of this effort to produce a lot of material in Portuguese, even about the CISG. And now that material becomes a little more important because Portugal has just joined, right? And so the scope of the Portuguese speaking CISG world has just gotten a little larger. And well, I'd like to turn now to Fabio. And Fabio, what I propose is that, if possible, you could discuss with us in your experience in several global corporations. What is the practical reality of negotiations of applicable law? Is that something that companies think about in advance? Would you agree with that description of that being a midnight clause, something that comes later in the process? Or if you think about some of the things Edgardo mentioned about this wide range of legal systems, right? How much do you think companies think in advance about this menu of applicable laws in how they should where they should choose to have their contract governed by which law, considering this great diversity of systems, right? So can you share with us some of the realities of that type of reasoning?
Yes, Cesar, thank you very much. Thank you for inviting me for this conversation, and very glad to be in this very expressive group. It's not for a reason that applicable law in jurisdictions is in the bottom of any contract. It's because in the bottom of the importance of any contract. If we understand the psychology of a contract negotiation, it's not in the radar, ever. No contract negotiator, no commercial guy will ever think about applicable law and jurisdiction, because they want to think about delivery, they want to think about price, they want to think about quality, and these are the core of a contract. They think about allocation, they think about risk sometimes. Most of the time, they are not even thinking about risk, because the psychology of the contract is to be fulfilled, is never to be breached. So it's counterintuitive for someone that's leading a negotiation with someone that you believe will be your partner, that you marry for some reasons, because when you sign a contract, it's like a marriage. You're believing that the other party will fulfill its obligations. It's counterintuitive to spend much time when we're talking about what happens if it doesn't work. We don't spend that much time on discussing with your fiancé what we will do when we break up. No, we'll just break up, right? You talk about love, you talk about how you're gonna get engaged, you talk about the party, who you're gonna invite to the party, but you don't talk about who's gonna get the kids or who's gonna get the dogs. So it's the same psychology of a contract negotiation. And we are sometimes, let's see, the weak link on a contract negotiation. We are pressured by time, which has to be. We are pressured by the commercial and finance guys to close the deal, because it's much more important to close the deal than to not close the deal. Otherwise, we would not be on the table of the negotiation. And then at the end of the day, Friday, 10 p.m., we have to deal with the discussion of applicable law and jurisdiction. Sometimes, of course, we have months to negotiate certain clauses, sometimes we don't. So the first thing I would like to bring to the table is, do not expect from your other players or stakeholders, they would care about this, because really is not that important. And we as lawyers should be humble enough to understand that this is not important to everybody. It might be important to us because we are always envisioning the possibility that maybe in a small percentage, something might go wrong, because we have to believe that most of the contracts do not go to arbitration and do not have dispute resolution. But when they do, they might have a high impact. So since it's high impact but low probability, the people involved in the contract negotiation are not going to put the most energy on this, and they should not put the most energy in it, knowing that this should be something that should be facilitated from us in a way to make not only the deal closed as fast as possible, but if happens, when it happens, is not so traumatic. We always will be traumatic because it's a breakup, right? It's something that no one wants to happen, but not as traumatic as is sometimes can be. So the choice of, I had some experiences, very interesting experience in the choice of law. When I was working at Embraer, we had supply agreements with many countries, and we used to use, and it's very traditional aerospace business, to use New York law. New York law is the choice of law for 90% of the contracts on the airspace, especially, and the jurisdiction would be the Southern District of New York, which is very specialized on dispute resolutions for the airspace industry. But then we decide to make a joint venture in China. And in this joint venture, we had to make a three-party agreement with all the suppliers, because we were going to build a new aircraft in China. And to build this new aircraft in China, we need to have a joint venture in China. So there are two parties, we and the Chinese party, plus the supplier that are spread all over the world. The first thing we faced, going back to the psychology of the contract, is people don't trust each other sometimes when they don't know enough about each other. So for no reason, I couldn't accept, and I didn't have any objective reason to accept Chinese law. The Chinese, for no reason, technically couldn't accept New York law. And our suppliers didn't accept any of those because whatever was happening. And for exclusion, we accepted Swiss law. So why did we choose Swiss law? Maybe because we didn't know Swiss law. Maybe because we're not Swiss. And that was the amount of research I did to choose Swiss law. Why Swiss law? Because there's the one left. Because there was the only one everyone accepted. There was no possibility of Chinese, there was no possibility of New York law, and there was no possibility of British law. So maybe Swiss law, okay, maybe Swiss law, and everyone accept. So sometimes you have to think about the best is not what we can get. Sometimes what we can get is what we can get, what's viable. And if we understand a little bit, the most of the time, when we talk about choice of law and dispute resolution, we're talking about fear, which is very different when we are talking about price and we're talking about commercial provisions, that we are not talking about fear, we're talking about gain, right? The psychology changes. And most of the time, we don't have the tooling that we need to have. So if it was a good decision, it was a bad decision, I don't know. We chose Swiss law. Luckily, everything went very smoothly and we didn't have dispute resolution under Swiss law because I didn't even know how to start it. So this is just, I want to bring a little bit of the experience. And it was a multi-billion-dollar deal. So of course, I had no leverage to stop this kind of negotiation and go do a deep diving under Swiss law and make comparisons and maybe take some provisions. Well, accept Swiss law, but we do not accept this part of the Swiss law because it conflicts with Brazilian law. I don't even know if there are major conflicts between Swiss law and Brazilian law. And if they would arise, I had no idea how to deal with those conflicts. However, that's perhaps what happens. I don't know if this experience happens to other people, but it happened to us. And I would guess it happens a lot all over the world. So perhaps the choice of law is sometimes intuitive, is sometimes Luck is sometimes we get what we can get, or sometimes it's just a top down from the most power to, and this is what happens most of the time, is from those who have the upper hand of the negotiation impose the applicable law, and that's the reality in 90% of the cases. So would be a, let's say, a very nice world where we can sit and go deep diving in 100 jurisdictions and 100 laws and understand what's best for that specific deal. But that's very unrealistic, especially when we are pressured over time and in companies that need for some financial, are dependent in that moment to close the deal for whatever reasons they have. So that's just let's say the little bit difference approach that would bring to the table. Let's say the optimum would be would do a, let's say, a more smart and complete job that we actually do when we go to sit and discuss this kind of clauses. Thank you, Cesar. Thank you, everyone. Then I will come back later to give my comments.
Thank you, Fabio. This is extremely interesting. And before I turn to Diana, I was just going to mention that I have seen in some cases situations that are similar to what you described, in which parties come to something like a deadlock, and they finally decide that they're not going to choose any applicable law. They will just leave it to luck and find out later what the applicable law was. And so I'd like to pose that question to Diana, if she has seen something like that, and if you think, Diana, that in a situation like that, the risks of finding out later that the applicable law was something that you never even envisioned when you entered the contract is great enough to recommend some deeper reflection at the time of the contract, or if, as Fabio said, the other considerations, the other things you need to take into account when getting into a contract just trump that issue, and it's not one that would be worth stopping everything to decide in a more informed manner, right? So that's one thing. And the other thing, I've seen companies that try to get some type of preparatory thinking about those issues, and have something like a menu of laws that they know, even if they don't know in depth, they know pretty much, and they think they, as Fabio said, okay, for air and space deals, New York law. Okay, so that's the industry practice. That's easier in a way, right? But you may have a collection of possible laws that may make the other side happier if you accept, and you may come to the conclusion that they are not really that bad. And how do you see those things? Do you think that happens? That's just wishful thinking?
Yeah. Hey, thanks, Cesar, and thank you, everyone. I think there's been great comments and a lot of smiles in my face as well while I've been listening to everyone. Yeah, Cesar, I have to admit, I guess I have this menu of governing laws in my head, at least not on the table necessarily, but yes. And I have had, most of my experience, they come from working for groups with European ownership or so. So, of course, from that perspective, maybe I have more of options on my menu, because often I feel more comfortable with European laws than outside of Europe laws, right? So, of course, then I would think, the most top 5, top 4, which I feel most comfortable. Then I have the area of the laws within Europe that I don't feel that comfortable. I know some of the problem areas there, but maybe I could accept that, and so forth. And then maybe few which I really try to avoid, even within Europe. But yeah, but it would be still maybe better for me than going forward with a non-European governing law. But if I think in general, I think there were good comments. I mean, I would feel uncomfortable, I guess, of choosing a jurisdiction that I don't have any knowledge, right? But I guess Swiss, we always have some sort of a knowledge out of it in the legal world, so it's not a total kind of a surprise as with some other potential legislation. So maybe that's often the reason why it's kind of a compromise as well offered. But I think I kind of agree with Ingeborg that we kind of, when I'm thinking of the governing law, I try to take still rather flexible approach and practical. I mean, major thing is really, of course, that you're not kind of building up a setup that will not work in practice. And in the contract, you might eventually agree on a governing law, but you might have other legislation still to be considered through, let's say, for example, standards, if there is certain references in the contract for those, mandatory laws that might be applicable depending on the type of the contract you're involved, and so on. So it's not only maybe that one phrase that you need to consider there, but it's a bigger picture, and then you need to kind of take into account the whole of it and how it works eventually in practice. So that's something I think, and we have had, and I have had in the past, in several occasions, quite complex setups from the start, where the counterparty has required, for example, standards that relate to the use of the products, but agreed on a compromised manner of agreeing an arbitration under a well-known legislation, but having it close to the place where he or this counterparty is located. So all those kind of things together, yeah, you need to accommodate the other party, you know, and get to the solution. But you can't do it blindly, right? So you need to try to find a setup that works also in practice, and you don't have this kind of eventually in practice something that it's not doable. And I bet, I'm sure, like Ingeborg probably has example of those cases where you come to a situation where things don't work in practice. So I would be kind of relaxed with my menu of jurisdictions. So if I have the top 10 from my list, I'm rather relaxed. And of course, it depends which counterparty I have. So am I, you know, if it doesn't necessarily make a sense if you have, if you are making a contract with two parties that are from certain legislation, and then you seek for a governing law outside of that legislation. You really need to have a real reason why you are doing that, why you putting it outside of the country where the parties are, for example. But we do have risky jurisdictions. We have corruption. We have external experts that tell us in advance that yes, in this country we do have that possibility. Obviously, you try to avoid that kind of a setup, and yeah, I guess I'm in favor usually on arbitration in any case. You know, it's faster, it's costly, yes, but it's faster. You get the expertise you need. Today, I mean, we are in the digital world. You know, we have complex setups, and we really need to have those experts in place. Why not to have the arbitrator there? Because anyway, a local court would need to engage one, and if they wouldn't, they would be lost probably. So that way, I feel kind of confident on picking up the right law, let's say, a law known for everyone that practically works, and then really kind of trying to get it under the framework of arbitration.
Thank you, Diana. We will certainly go back, especially with you and Fabio, about the some reflections on whether the CISG as a uniform law would be something to consider in these contracts, and as a way to avoid some of that maybe that transaction cost that would be the idea of having to sit down and discuss laws that the parties are not familiar with. But before we do that, I'd like to turn to Eduardo, who has an experience that's a little different, because it focuses mostly, as I understand, on large infrastructure contracts, construction, and we will certainly discuss later to what extent the CISG can help in that regard, because it, as Ingeborg will be able to discuss more later, turnkey contracts are one type of contract that can benefit from that type of uniform law. But what is your view, especially since you are involved in Brazil with a Chinese based company? What is your view, especially on this relationship between Latin American countries and Asian countries, or Latin American companies and Asian companies, with regard to the negotiations of applicable law? Do you think that makes any difference, or is the picture pretty much what we have been discussing?
Hi, good morning, Cesar. Thank you very much for the invitation. Good morning, good evening to all. Well, first of all, I'd like to say that I totally agree with Renata and Fabio when they said that it's about the midnight clauses and the last thing that you normally, when you're negotiating a contract, you don't discuss that, but I agree that it's totally important to have this very clear for the parties in a contract. In terms of engineering construction contracts, I believe that, in my opinion, we are one step behind of sales contracts in terms of like having a common and like alignment of these rules for the contract. Because when you're talking about applicable law in infrastructure projects, normally you're gonna be applying, like at least in Latin America where I work, you're gonna be applying the local law, because when you say infrastructure, you have at the end of the day, like the government, and you are working the public sector doing a construction in the country. So the applicable law in the majority of the contracts, they follow the like Brazilian law, the Peruvian law, or the local law. So the international companies, like, for example, CCC, that is our shareholder today, when they come to Brazil, and also we have here in Brazil, for example, Spanish companies, other European companies that are EPC contractors. That's why I would say that the first thing that they spend a lot of money with lawyers to understand the local law. But of course, you have a few mechanisms to protect and to have an understandable for the parties of the law, and at least in terms of the dispute resolution, like arbitration is being every day more used in Brazil, and we are using like European cameras for the arbitration. Also, we don't follow the CISG, but we are starting to use more. I don't know if you're familiar with this kind of contract. It's the FIDIC. FIDIC is the International Engineering Federation that have a standard for each kind of contract. For example, EPC contract, design build contract, each model, they have a standard. In the public sector, we do not use yet, but I think it will to come. There are some countries in Latin America that are starting to use FIDIC. And also because the World Bank, which is the main funding for the infrastructure in Latin America, they are starting to recommend also FIDIC. So I believe that we have a large room and a lot of time to improve these rules in terms of infrastructure, and also try to use the CSG. For example, when you have a EPC contract that you have to import a lot of equipment from overseas, the purchase of these equipments might follow the CSG because you are purchasing an equipment that will be inside the CSG rules. So what impacts these contracts can have in the mother contract of the EPC contract. So a lot of these discussions are every time that we have an EPC contract that have a component of importation of equipments and of materials from outside of the country, we start to have this kind of discussions. And certain for these contracts, you need to have arbitration clauses if you have any dispute about this. So I think in the next topic, right, it says we'll talk about more dispute resolutions. This is where I think I maybe can add more, because when we say about applicable law, most contracts that I've been working, they follows the local law because we have normally infrastructure projects that you have the public sector as the final client. Even if you have a concession contract or a PPP contract, normally the applicable law will be the local law. So I think when we talk more about the dispute resolutions, I can add more comments, and I'll be able here for answering some questions. Thank you.
Thank you, Eduardo. I just have a quick question for you on something that you mentioned about contracts with subcontractors. Do you see a clear concern about mirroring provisions in the subcontracts that are in the main contract, so that, for instance, if you have CISG applicable to the subcontracts, and do you see at least a concern that some of that should be also in the main contract, so that there is no conflict between those obligations, or do you think those are two separate moments, and normally things are not considered globally like that?
No, yes, I totally agree. We, for sure, when we have like an EPC contract, we, as a contractor, we try most to reply the same clauses and conditions to the subcontractors. Of course, sometimes the subcontractors, they're smaller companies and they cannot, for example, achieve the same kind of insurance and warranties and bonds. When you have like a performance bond of 20% or 30%, is too large for a subcontractor. But normally the subcontractors, they are in a weaker position, unless when they have a technology or a product that you don't have a lot of competitors. So, for example, we are doing some gas pipeline contracts, and sometimes you have some technology methodology that are not used in Brazil, and you need to hire an international subcontractor, and they will ask for some conditions that in the negotiation you need to agree with some of that. So is always for me a matter of who in the negotiation is in a stronger or weaker position. When you are subcontracting something that you have a lot of competition, I will ask to put the subcontractor the same conditions that I want, and they will accept because they have other compact. One will accept, and that's what happened. But when you are buying something that is only one or two suppliers, they will have more efforts in this to put their conditions. So I think that is what happens normally.
Thank you, Eduardo. Before we make a round back to Ingeborg, Renata, and Edgardo, I would just like to ask Shirley. Shirley, would you like to make any comments on this issue of applicable law before we go back to them?
I was going to say comments for applicable law in correlation to the arbitration agreement, because we all know that's quite a fun, happy topic as well.
Okay.
But we can tie that with dispute resolution, and I'm happy to hand it back to Ingeborg and Edgardo.
Right. Thank you. Ingeborg, Renata, and Edgardo, given some of these experiences that Diana, Fabio, and Eduardo shared with us, well, I'd like to go back to you now and hear you about how do you see those things, and how do you see what do you think can be improved, or if or how we deal with that reality in terms of as Fabio mentioned, making things easier for the transactional lawyers, so that, since to use Fabio's metaphor, we are all kind of divorce lawyers here, right? And so we see things when they go wrong, not necessarily when they go smoothly, as they usually do and they should. So how do you think we can make things easier and more effective, if possible? So I go back to you, Ingeborg, Renata, and Edgardo, about these topics. Ingeborg?
Well, first thing, if the CISG applies, don't opt out, and if it does not apply, try to opt in. The more people get to know the CISG, the more they realize that it is superior to any domestic legal system. Fabio, you mentioned New York law. I once had a long discussion with the legal department of one of the leading companies of Japan. All lawyers in the legal department have an education in the US. So they said, okay, we concede, we apply New York law, we know what New York law is. And then they had a big litigation. And suddenly they had a very detailed contract with wonderful contractual terms, but the other side suddenly relied on tort law. Yeah, they had excluded the CISG. If they had not excluded the CISG, relying on this specific tort law remedy would have been excluded. So it would have been predictable. And likewise, if you choose Swiss law, that's totally unpredictable. Switzerland is such a small country, 8 million inhabitants. Core questions of contract law have never been decided by the Supreme Court. So you get a good legal expert, and the one who is better on cross-examination will win your case. So that's if you choose Swiss law. And finally, EPC contracts. Actually, it's funny because right now I'm involved in 4 investment arbitrations, actually, where we have a state party on one side. And in all these contracts, we have the local law as the governing law of the contract. One, for example, is a power plant in South America. And the law of the country has been chosen, and the state relies, this is our domestic law. No, it is the CISG. Yeah. And why? First of all, EPC contracts do not fall outside the CISG turnkey contracts, because goods to be manufactured are well governed by the CISG. And an EPC or turnkey contract has to be judged by Article 3, Para 2. That means only and only if the services part forms the preponderant part of the contract in relation to the delivery obligation or the manufacturing obligation, then it's outside of the CISG. But whenever the services part is not the preponderant part, it is the CISG that applies. Even if you've chosen Peruvian law or Chilean law, whatever, it's the CISG.
Thank you, Ingeborg. And Edgardo, would you like to comment on some of these topics?
Thank you, Cesar. Yeah, I think there is already an advantage in the position taken by most general counsel on simply choosing the law of a country without excluding the CSG, because in many situations the CSG will in any case apply. Maybe they ignore that, but at least it's good that they do not opt that out of the CSG. For me, what caught my attention was what Diana Maher said. It's true that today international sales have become very complex because the different private or public standards that may affect the use of the goods, and we see that in some scenarios it is even a bigger concern to see which public standards may affect the resale or use, or even private standards in supply chains, right? Ingvar and I just wrote an article on that respect, on sustainability in global supply chains. And we realize that it's very important to bear in mind those standards. And I think the CSG is a good instrument in that regard, because the CSG in Article 35.2, A and B, allows the parties to call, for example, in 2B, call the attention of the seller with regard to the particular purpose that the goods will have in a particular scenario, right? Climate conditions, or simply the use of them in a specific country. And by letting the seller know a particular purpose, many of these standards will become part of the contract, will become applicable to the contract. And in some regard, the seller should be very cautious, but the CSG strikes a balance there, because this provision states that the seller should only comply, or is bound to comply, with this particular purpose if the buyer could reasonably have relied on its skills and judgment, right? So it's not like the buyer can simply say a particular purpose and that a standard will be incorporated immediately. It is important also that the buyer takes precaution of knowing who is the seller. And if he knows he cannot rely on the skill and judgment to comply with those standards, I think the buyer should incorporate it directly, specifically into the contract, or to give more information to the seller. And in some scenarios, when there is no particular purpose, still some of these standards, private or public, may become applicable depending on the goods, because the second default guarantee of the CSG states that the goods must be fit for the ordinary purpose that similar goods have. And we know that goods of certain characteristics, like drugs or medicines, are subject to standards everywhere. So it is reasonable to understand for the buyer, for the seller, that irrespective of the fact that there was a particular purpose, the circumstances surrounding the case, is on position how the seller advertised itself or herself, would in various scenarios, or in many instances, require him to comply with these public standards at the place of use, so that the goods can be used in its ordinary way. That is what I wanted to say with regard to what Diana mentioned. Thank you.
Thank you, Edgardo. And Renata, before we, I would like to ask later Fabio, Diana, and Eduardo to make some, if they want some final remarks about applicable law. But before that, Renata, if you could please comment on these topics, especially from a Brazilian law point of view, but also from I think one common concern, if I understood it correctly, is that if you are able to choose some applicable law, you would choose a law that would uphold the contract, uphold what the parties intended, rather than bring surprises like what Ingeborg mentioned about the use of tort law or things that you hadn't really imagined when you entered the contract. So if you could please also address that, address this issue from that point of view. Specifically, do you think the CISG would give that type of certainty and predictability, and is that a way to maybe avoid these surprises, these undesirable surprises?
Thank you, Cesar. Also thank Diana and Eduardo and Fabio for their comments. And I'll address your question, but before I'll just, if Fabio allow me, you said about marriage, yeah. So modern marriage, maybe people are discussing prior to getting married some topics on how things go if they get a divorce, or if they have kids, or even if they have a dog. I think the main question here is if you really are going into a marriage or you're going just for a date. If you're going just for a date, it's a spot contract, maybe that's not really relevant to go or to spend your time and your money, therefore, on those clauses, yeah. But if you're going on a long-term relationship, maybe that's a good thing to do, because even as a scholar, I'd love to discuss these topics, but getting your point of view as a practitioner, I would say that's really a nightmare to bifurcate the proceedings in order to first get to know which is the applicable law for a relationship that you already have and that you already comply with and that you already rely on. So that said, and about certainty and surprises, that's the question that Cesar just asked me. It is impossible, I would say really impossible. It's an impossible task to know a legal system if you're not part of this legal system. And as a Brazilian lawyer, I would say it's almost impossible to know Brazilian law. I know a part of civil law. I don't know Brazilian public law. And if you ask me about Brazilian labor law, I have no idea how that works. And even though we may have in Brazil a civil code, one reads the civil code and then one thinks, okay, that's the rule. And then we have courts that apply this rule differently. We have scholars that that make different interpretations of this specific rule. And that's not just a Brazilian issue. That's actually a problem with all legal systems. It's like an Italian scholar, Rodolfo Sacco, he says that in order to understand a comparative law, one must understand, he says in Italian, formantes, which I could translate as like the elements that form a legal order. And that's very, very hard to do. So relying on CISG does not, of course, eliminate those risks, but it really minimizes any risks of surprises, because a CISG was built to international players and was built, and I'm going to use an expression that Professor Schwenzer uses in one of her texts. It's a happy fusion of civil and common law systems, and it's been applicable since the 80s. And it's Portugal has just joined the CISG family, so the family has increased and not decreased, and that means that if players in international trade, not only in international trade, are going for certainty and profits, and they are still using CISG, and they're using CISG for not only sales contracts, but all EPC contracts, turnkey contracts, and other contracts that have a link to sales. That means that the surprises in this field by applying CISG would be really, the risk would be less than choosing a domestic law, which you would not know entirely. Thank you.
Thank you, Renata. Fabio, Diana, and Eduardo, any final remarks about applicable law before we move to dispute resolution?
Just a small comment, regarding what Inga and everyone else talk about. In the healthcare sector, we live upon protocols, right? The doctor, when they have some medicine, it's in respect to a protocol. When we have some pharmaceutical product, we know exactly the protocol, how many doses, and for what kind of pathology needs to be applied. So in respect to what kind of law we choose, if we have protocols like ICSG brings to us and brings this predictability, it helps the sector in a long term, in a long run, because everyone will be acting in a very similar way and expecting the similar outcome. Of course, the choice of law, it's important, but sometimes we don't have the luxury of having much time. So we need to be prepared in advance. We need to understand who is that supplier before we sit on the table, and to understand what kind of product he's selling and the amount of risk that such deal involves. At the end of the day, it's a risk allocation decision, right? At the end of the day, there's a lot of risk allocation decisions that we're gonna have to take in the negotiations. And this is one of the major issues. And we're gonna have to give some to gain some. So if you give some on a scenario where you have what's being said, predictability, no matter what law you choose, if there's an insert protocol in that law, like ICSG, that brings some predictability, it makes much more comfortable to live. If I remember, like long time ago, the revolution that Incoterms brought to international deals, we just put Incoterms there and it's done. You know who's going to pay for the freight, and you know who's going to be responsible for the delivery, and should be delivered at the harbor, should be delivered at the door, or should get your good from the supplier's facility. So it was a protocol. No matter what kind of law you choose, you put Incoterms. And if the whatever applicable law accept the Incoterms as a term, or the judge will read the Incoterms, because the Incoterms are so easy to read, they're going to say, well, that's the provision written by the parts within the contract. Even if the law does not have any reference to the Incoterms, it's like if we have wrote that provision. So as long as we become more protocolized, I think we be more peaceful on the dispute resolutions. We might avoid dispute resolutions, or when we go to dispute resolutions, they're going to be much easier to be handled, because there's certain, let's say, we beginning from certain level of knowledge that it's not only one person or one two parties or three parties or four parties are negotiating, and they're only them know the expectations. The parts that are being brought to the discussions will have certain basic level of the knowledge of the expectations that we're supposed to have, because we are using Incoterms, because we are using ICSGs, or because we are using certain standardized provisions. So I do agree that makes easier to navigate dispute resolutions when we have standardized, protocolized prescriptions, like we do when we use medicine, when you use doctors' prescriptions.
Thank you. As Edgardo mentioned, one of the virtues of the CISG is precisely to incorporate those standards and in what you what you look for in that kind of context is an applicable law that will not change what the parties imagined they were entering into when they concluded the contract and adopted those standards or protocols, right? And, Diana, would you like to make some final comments before we move on?
Yeah, I think, very, very good comments. And I think the Incoterm is an interesting example on how things can get known to the world and used to the extent that Incoterm actually has successfully achieved. So that's true. I think maybe just, obviously, I think one point maybe we haven't discussed, I don't know if we have time here, is a little bit related to CISG and let's say the case law in relation and its future. And then I think from my side, maybe still to the applicable law, I think it's a matter that we need to kind of remember also to take it into account quite early stage of the negotiations, because you can't have the full package done and then suddenly realize that the choice you have then at the end agreed doesn't really work from good faith perspective or force majeure perspective or any kind of perspective of important clauses depending of the jurisdiction. And I think us as let's say professionals within the legal field and involved with international business, we have a little bit of a heavy burden, because you can't anymore go around without understanding at least some parts of each of the jurisdiction that might become the governing law for your contract. You need to have a little bit of a feeling at least of the main risk areas, and that's a difficult task for one person in charge of that and of course, I mean, CISG is maybe there in the future then to help and assist in that perspective, but it might be still that the level of knowledge of CISG is not there where it should. But that's all from my side for this. Thank you.
Thank you, Jenna. And I will turn to Eduardo now, but before we go to Sherlyn, I would like Ingeborg, if you could just quickly after Eduardo makes his comments, comment on what Diana said about the case law on the CISG and how that helps or doesn't the predictability of how the CISG should be applied. And Eduardo, your final comments on applicable law?
I have only one comment regarding what Ingeborg said about when you have an EPC contract, that's most part of the contract have an equipment, a manufacturer equipment that will apply to CISG. I agree with that, and because normally the equipment provider will have these clauses of CISG to have the CISG rules. But the problem is normally the final client, which sometimes is the state, don't want to have, don't want because he doesn't know, like Diana said, they don't know what are the rules, so they are afraid to put some rules that they don't know, and then because they're the public sector, they have more strength. But the good news is that now, for example, in Brazil, we are under discussion the new bidding law, the new public bidding law. It's not only public bidding law, but also public contracts. And in this new law, they have a new article that when you have like a construction company that you have some kind of equipment or technology that is different, they are able to have like a provision to have a competitive dialogue before the bidding. And this competitive dialogue, the suppliers, they can propose some rules and some rules. So I think that can have a good place in Brazil to start to have this convincement and I think this will be really good for the local market, for example, to start to have more this knowledge about CSG and other applications. So maybe this can be good opportunity here in Brazil. Thank you.
Yeah, I think that's a good thing that you remembered. We need to be aware of those tools that we have, and take advantage of them to remind the government, for instance, that they can apply the CISG, and that it has advantages that they should not ignore. So, now, Ingeborg, if you could please make some comments about what Diana and Eduardo said regarding this lack of knowledge about the CISG and what's available out there in terms of case law, these things, before we move on. Thank you.
First, I wanted to give an example of what Diana said about the choice of law clause conflicting with the contract. I experienced several times that a contract was drawn up by English lawyers, and in the end, I found a choice of law clause, Swiss law applies to the contract. And then you have this conflict. It doesn't match, and you can do anything you want as counsel or expert witness. To bring them together, but it just doesn't match. So it's really important. So case law and literature on the CISG is much better available than any case law on a domestic legal system, because case law and literature are freely accessible on databases in the internet, and usually, well, most of it in English. So you have databases on case law where the case law from Spain or the Netherlands is translated, as at least in an abstract, translated into English. Whereas if you choose Swiss law, you don't have access. You have the language barrier, and then you have a cost barrier. Yeah, you must access very costly Swiss databases on Swiss law, which is not the case with regard to the CISG. And what is very important, well, Cesar mentioned my commentary actually. So this commentary has been translated actually in Spanish. My co-editor is Professor Edgardo Munoz, and Cesar was very much engaged in the Portuguese commentary. So you have this commentary in different languages around the world. So the Brazilian lawyer, even if he's not very, very good in accessing English databases, English speaking databases, he has the Portuguese commentary. And it's the same like the American lawyer has in English or the German lawyer has in German. So they can communicate and still have their own language commentary, which I think, which is unique. You don't have that with any domestic legal system.
Okay, well, thank you. This has been a very, very interesting discussion about applicable law. And we will turn now to our second issue. And Sherlyn will lead us on that. And that is the negotiation of dispute resolution provisions, place of dispute resolution, forms of dispute resolution. So Sherlyn, can you please give us some light on that before, so we can start a discussion on that topic as well?
Yes, I think I'm going to be very, very brief on my introduction or background, given the time and also the fact that I think the discussion part is going to be much more interesting because we're going to get actual experiences and real life situations, because I can keep harping on certain things, but everyone can read articles and understand hopefully certain positions, and then it would also be less organization for me. But what I had said earlier, with respect to governing law, one thing that I did want to kind of reach it into arbitration in particular is that in recent times, the arbitration world seems to be quite enthralled with the topic of governing law, particularly with an arbitration agreement. And this is in light of the recent UK Supreme Court decision in Inca v. Chubbs. It's quite an interesting topic, I think, for me as a practitioner, but also from the time when I was an in-house counsel, because this is just personal, so I could be wrong, but when I was an in-house counsel, I experienced my colleagues not really understanding the concept of why it's important to choose a particular governing law, not only for the contract itself, but why would we also need one for an arbitration agreement? Everyone knows, and it's been mentioned many times, this governing law and the arbitration clause is always the midnight clause or the champagne clause. And it's something that we as practitioners try to avoid by educating. And I'm glad that we're having this session here today, because the governing law is not only important for the contract itself, but it is important for an arbitration agreement, because it will determine certain aspects of how that arbitration agreement should be interpreted. Now, stretching it out to a place of arbitration, why is the place of arbitration important? Oftentimes you see a lot of confusion, because as we know, arbitration is one of the private dispute resolution mechanisms that parties choose because, number one, they want neutrality. But at the same time, there isn't really a clear understanding of the difference between what is a place of arbitration and what is a venue. So for example, coming from an American background, we've got a venue for where we can actually hold litigations or where we can commence a litigation. So when you oftentimes see Americans commence arbitration, they do kind of mix what is a venue and what is a place of arbitration. Now, international arbitration, places of arbitration basically is the legal framework of the arbitration procedure. And it has quite an impact on how a dispute can be resolved when the parties have chosen to resolve the dispute by arbitration. But then when the parties don't really take into consideration the legal impacts of the place of arbitration, that's where you actually see a lot of issues arise. And one of the main reasons why we choose arbitration to resolve disputes, in addition to neutrality, is the fact that we actually want to resolve the substance of the dispute. But because of the lack of understanding on the importance of the seat of arbitration, you oftentimes see parties embroiled in millions of dollars of legal fees just deciding on certain procedural aspects. So why is the place of arbitration so important? It's because, as I said earlier, it's the legal framework, but what do we mean by legal framework? One, the place of arbitration is important because it also determines how involved a legal system in that particular place of arbitration will get involved with the proceedings. You want to choose a place of arbitration that is very arbitration friendly so that you don't have the courts unexpectedly or getting too nosy into your arbitration proceeding, not allowing the neutrality of the arbitral tribunal to carry forward. But at the same time, as we know, the power of arbitral tribunals are somewhat limited to what the parties have agreed upon and only can apply within the scope of that arbitration. So parties who choose to do arbitrations also need to rely on the legal systems to kind of support the arbitration proceedings itself. For example, with interim measures or discovery orders, orders for witnesses to appear, things along those lines. And oftentimes parties will choose a place of arbitration not knowing that this legal aspect itself is important. The place of arbitration is also extremely important for your ultimate final award, because that's going to determine the options of how a party can try to set aside an award or enforce an award. So again, you want to go look for a place of arbitration that is extremely friendly rather than a not so friendly place of arbitration. Now, before we kick off into the discussions, what I do kind of want to do, because we are here on behalf of the This East competition, which is based in Hong Kong. Also, I understand about a month or so ago, the Financial Times published an article that said that a number of companies are now deciding to write out or deciding whether or not to write out Hong Kong from their legal contracts. And I am here kind of tooting the horn on behalf of Hong Kong to say, we really do need to take a look and separate the politics from the importance of a place of arbitration or a place where you resolve your commercial disputes in the litigation in the courts. One thing that people often forget is that China is, or okay, let me rephrase that. People do not forget that China is going to be one of the biggest economies in the world, but they do forget the fact that when companies enter into international agreements with China, what happens when the dispute arises? If you end up choosing no place of arbitration. If you end up going for litigation and you don't specify, for example, excuse my cat, he misses me. If you don't choose a good place of arbitration or a place to litigate your disputes, how are you going to ultimately enforce that judgment or award? The benefit of Hong Kong for a place of arbitration is that Hong Kong is the only jurisdiction worldwide that has a number of mutual arrangements with the PRC. So that basically means if you have an arbitration, international arbitration that is seated in Hong Kong, you have a number of benefits. For example, one, you can go straight to the PRC courts and apply for interim measures. And rather than the court taking a look at this application from square one, because you're in an arbitration seated in Hong Kong, they generally will just submit that application, process it through, and you will be able to get your interim measures with very little difficulty. At the same time, the PRC courts also recognize Hong Kong International Arbitration Awards as if it was, in essence, like a domestic award. So once you actually get that award where you win, you can take that award and go into China where the assets are from the Chinese companies and enforce with much more ease than you will be able to do if it's an award from an arbitral tribunal seated outside of Hong Kong. Also, the courts in Hong Kong are considered Chinese courts, but Hong Kong is also the only jurisdiction within China that has a common law jurisdiction frame or legal framework, and one that's recognized internationally. From experience, again, separating the politics from the actual court system or commercial courts, we have seen that the courts have remained independent and they have stuck by the pro-arbitration regime, and they have supported commercial disputes with companies that involve Chinese factors. So that's my 2-cent plug for Hong Kong, and also hopefully set some kind of a good framework for a discussion.
Thank you, Shirley. I've noted here several things to ask you, but I will just get the discussion going here before I do that myself. As we had discussed, I will now ask Diana, Fabio, and Eduardo to make some comments on the issues related to dispute resolution. And starting with Diana, and I think one thing that that may be a first question to discuss is whether there is a difference between the approach companies take to the discussion of applicable law and the discussion of dispute resolution. My intuition is that even in practice, we do spend more time in talking about dispute resolution. It's something that companies think about a venue or what institution to choose, maybe because of something Fabio mentioned, that this is the section of a negotiation that it may have to do more with fear than with the main purpose of building something through a contract. And so do you think, Diana, and all of you, that companies do spend more time and reflect, think more about dispute resolution than they do about the applicable law?
Okay, good question. Maybe, maybe hand in hand. I think, I mean, dispute is a bad news, right? But in a relationship, you have disputes. How you manage them, of course, is the question. The fact that you end up in arbitration or litigation is even worse news, right? Costly, time-consuming, resource-consuming, not from just pure money-wise, time-wise, your management, your own time, and so on. So it's really bad thing. And of course you have all these contractual wordings where you put certain principles nowadays where parties should try to find first amicable manner a settlement in case of differences, and only after that go to the arbitration. Are those kind of reminders in the contracts that yes, you need to do that? Many of us think they are nonsense clauses, but are they nonsense? Mediation, I haven't experienced that many, but the one I did, it solved the problem, but I felt it beat it still. Even we got to the kind of middle way. Yeah, so I think we for me it would be kind of a hand in hand. Yeah, so because they relate so much together, and I like the fact that Sherlyn highlighted the point that you need to think of the kind of the friendly arbitration jurisdiction or venue and so forth. That's an important point. We have countries that have a massive market presence today in the world, through their funds and infrastructural setups and whatever, and who haven't been at all arbitration friendly before, and they have started to be now recently. I recently changed with one contract the litigation in the courts as a venue for the dispute resolution into arbitration of the local the counterparty's local jurisdiction, and I felt that was better for us, also from the aspect of potential corruption. It was a big change, but we needed to get familiar with that. And then it comes the question, what Shirley mentioned. Okay, there is the arbitration. They want to promote that. They want to show to the rest of the world that, yes, we are modernized. We do have now, new institutes put in place and so on. We don't want to have them having, a bad reputation. And then it's the question, right? Okay, good, but how will the local courts then, follow those? Are they as modernized as, maybe the market wants to be, the legislators wants to be, of promoting those institutes? So yeah, I think it's a interesting setup, and I think it's such a key issue that you need to kind of protect the fact, for example, that whatever you agree as a dispute resolution venue or method or whatever, you need to ensure that obviously that kind of decision would not limit somehow the proceedings over assets of one of the parties in the contract. So I think that was a very interesting to hear PRC versus Hong Kong relationship there, and to understand that a bit better. So yeah, but Cesar, I think for me, I think it's kind of you need to match them. It's what we started with, that you need to, not complex the situation too much, but at the same time it has to be workable. It can't be like Ingeborg was saying, that you have a contract stating about good faith, and then at the end you agree that it's under English law. So it's like, what are we doing here, right? So yeah.
Thank you. Yeah, I think one of the challenges is really how to get reliable information and not base some of those decisions on assumptions or prejudices, right? Because you do need, if you're going to make an informed decision about which jurisdiction is reliable and what courts are specialized enough to handle arbitration cases, you need to have actual information and not only these general impressions, right? And Eduardo, if you could please make some comments. I know you have a special interest in mechanisms to avoid disputes, right? And not only dispute resolution.
Yes, thank you, Cesar. In my opinion, first of all, I'd like to, one thing that I learned with the Chinese profile of negotiation. I've been working the last 4 years, and they said to me like once, normally here in Brazil, in all Western, we believe that when we sign a contract, we are ending the negotiation. And for the Chinese, it's the opposite. When you sign the contract, you are starting the negotiation. So when you change this mentality and you start to see, like, for example, in construction contracts, there was a study, I don't remember which university that made that, analyzed like large infrastructure contracts and concluded that I think 77% of that, they have changes during the contract of the clauses and conditions. When you start like a large contract, some unpredictable things that will make you sit with your client, even from the client perspective, or with by the EPC provider. So normally you can have a design change, some new technology that's doing 3 years. That we have a lot of innovation. Is very, very fast today in the technology. So you're going to have some new technology, some design change, some community or social demands that will change the necessity of that kind of construction. So because you have all this, we need to have in construction contracts some mechanisms of disputes faster, that you don't need to go to court or to arbitration. Because once you go to court or arbitration, what will happen with the EPC if you didn't finish? They will stop, the construction will suspend most of the parts. So in Brazil, we had a lot of these problems. If you see the number of constructions that were suspended, and you have a lot of construction unfinished, which is the worst case. So for example, I mentioned before regarding FIDIC, the FIDIC, they established like the dispute board, that you have like before you enter in an arbitration or court, you have this mechanism of mediation or dispute board, that you even have the procedures are very clear. For example, one part submits their proposal, the other have 7 days to analyze. You even have the time. And what Shirley said is very important. Like it's most important to have the clear procedures, then the chamber, which chamber will be, and what the mechanism in terms of final resolution. So in my opinion, like it's very important, if all the contracts you can foresee some dispute mechanism or mediation before you go to court or to arbitration. I think this can reduce a lot the number of cases. That's I think the contribution.
Thank you, Eduardo. And now, Fabio, how do you see these things? Do you think it's worth it to put effort into designing a dispute resolution system in a contract in a comprehensive way, a dispute resolution system that may involve, as Eduardo said, dispute boards or some type of conflict avoidance mechanisms, and in that is ultimately based on a more informed analysis of the situation of a certain jurisdiction. And how do you see the reality of dispute resolution negotiation?
Well, just to make a brief comment about what we were talking before, applicable law is very important, because we should not frame your contract without knowing the basic provisions of the applicable law that's relevant to the contract that you are generating. For example, you don't have penalties or fines in US law. And some people put provisions of penalties and fines under New York law, which are not enforceable. But you have another mechanism which are similar, which are liquidated damages that can be used as long as you have a formula that justify, instead of find out what are the damages are going to be in a very expensive, let's say, evaluation in the future, you pretty much anticipate what the damages are be, and under civil law, that would be similar to a fine or a penalty. So it's very important that when the applicable law is relevant, and you cannot have dispute resolutions, applicable law, and venue, something that are not connected and discussed as a whole. But I do agree in something that Eduardo said, and I do believe we live in a world of imperfection today. So the way we used to draft contracts in the past, where we want to predict everything that's going to happen, and we want to anticipate every single solution for every single problem that arises, is something that didn't happen in the past, even in the old times, and it's going to be much more difficult in the future. The technology is very, very fast. Let's say in the medical sector or in the technology sector, if I buy a product today, I have a different version in 2 months. So how do I deal with this impact? So maybe what I purchase it today, it's not good enough tomorrow, but the price is already negotiated. Should I just turn this contract down and start a new one? Should we try to evolve to something that Eduardo said, some internal way of something to solve what's unpredictable? And I do believe that's the right way of doing, because we live in the world of it's not complete, it's imperfect, and we are moving fast, and it's never going to be complete and imperfect. If you want to have a long-term relationship, we need to predict them unpredictable. And we are not taught about that. We always thought lawyers need to predict everything. Now, perhaps now we need to predict that we cannot predict everything and we cannot solve everything. And if you are a principle-based contract, it's much easier to solve. And if you go to a negotiation where you know what you want from the other side and the other side knows what they want from you in principle, and this is somehow addressed in the contract. And we try not to be extremely detailed, because if we are extremely detailed, we're going to miss the target, because things are going to change and we're going to be stuck on the details. So I see the way we should draft contracts now should be very, very different from what we do, because now we want to discuss what's the best case scenario or commercial. Should we write reasonable effort or commercially reasonable effort? I spend it sometimes days negotiating. Oh, in US law, no, we want commercially reasonable efforts because it's different from reasonable effort. It is different. So what? At the end of the day, the parties will litigate anyway, unless you are working in a good faith and you have the right expectations on principles. It was days and days and days negotiating commercially from reasonable effort. So it's so much money spent or something at the end on the future. It's just going to be related to our vanity, related to what we really want to impose on paper, instead of looking at the big picture. At the end of the day, the big picture is, am I helping these 2 companies or 5 companies? Because sometimes you have the bank, sometimes you have the government institution, all related to the same deal. So am I helping for this in the future to not have breakdowns large enough so we cannot sit on the table and find a solution for this new problem that was unpredictable? Or am I creating certain strict rules and strict provisions that just make us be very far from each other, because we be attached on the wording and not attached in the principle? So that's how I try now to go and move forward to a contract negotiation. And going back to jurisdiction, I think we should talk about enforcement. Why talk about jurisdiction if you don't get enforcement there? You know, you're just going to have a very beautiful award and you put on the wall, but you're not going to have the ability to freeze any bank account. You're not going to have the ability to stop what they are doing. It's just going to be, oh, well, we won the case, but you don't get it. So if you win the case and you don't get it, you lost the case. And I do have something that I always say to my team: if you go to court or if you go to arbitration, you already lost it. You're just going to decide how much you are losing, because you already lost it. You only win when you don't go. So we need to build something. Of course, that's also impossible every time. But if you go to some place where we want to avoid arbitration and want to build a contract, when you want to avoid arbitration and you want to avoid dispute resolutions mechanisms, you go in a different mindset. And try to build a contract in certain ways and look for a venue and look for jurisdiction that if you have to go, at least it solves the problem. Never in a good way. It's always going to be in a bad way, but solves the problem and you can move forward because it has enforcement. So I would bring these things about principle, the way of build a contract, looking a contract in a way to avoid litigation, whether it's in arbitration or court system. And if you do, you have enforcement. So I always try to have all those things together in a way to, before we go to a contract, we look to those aspects. And to build internal mechanism of dispute resolution, like Eduardo said. I think these are very key to very large projects because things are going to change all the time. Project managers are going to be sending emails every day, 5, 6, 7 emails, and these emails are changing substantially the contract because they bring new expectations all the time, and you cannot close the eyes at the end of the day and say, well, we do have a clause that said if it's not written by the general manager of the company who has authority to change the contract is not changed. It's a lie. The contract has been changed because the parts have been performing it differently and are building something differently and are constructing something different and are promising to delivering something different. No matter what you wrote 2, 3 years ago, or sometimes 10 years ago, when you're talking about a mining company, 10, 15 years ago, no matter what you said 15 years ago, the things have changed. The promises have changed and the performance have been done based not more in the contract, but in the email, in the WhatsApp that's been sent 2 days ago. So we have also to understand that the contract is not the only framework that we live. Expectation promises that are outside of the contract, even though we try to put clauses that protect us, like the no changing of agreement should be made unless it's written by the officers. If you go to court will say BS, because you have 10 people here in your company who have performed differently from what you promised. So I'm sorry, it just don't work that way. So if we go back to principle, if you go back to good faith, it's always going to be difficult, but maybe a little easier than if we just stick to the clauses of the contract that we created in a imperfect way, under pressure, years ago, without the knowledge of what was going to happen in the future. So that's what I just want to say about, for me, it's a little bit the way of the new deal should happen, no matter if we want or if we don't want. Looks like to me the reality of the world that we're living today.
Thank you, Fabio. Yeah, I think that's very important to highlight also how the procedure that the parties incorporate into the contract and how they live that relation, that contractual relationship is actually what's going to determine whether that's going to end in a dispute or to work out to the parties' benefits. Well, we are approaching our time here. So before I turn back to Sherlyn for some final comments on the dispute resolution issue, I'd just like to ask Ingeborg and Edgardo if you have any final comments on the topics in general. Ingeborg?
Well, I just wanted to, what Sherlyn said about the law applicable to the arbitration agreement. You mentioned Enka versus Chubb, the English case. There has been also a very recent German Supreme Court decision on the question of the application of the CISG. So that is the next question. Which law do we apply? And is that domestic law, or is it the CISG if we have the seat, or if the law applicable to the contract is the CISG? So that's just to supplement.
Thank you, Ingeborg. Edgardo, would you like to make any final comments?
I wanted to say that it's always great to listen to people like Diana, Fabio, and Eduardo, who dare to say how things work in practice, things that, for instance, professors or sometimes legal counsel in arbitration cannot say as they do. As this cocktail is also about Latin America versus Asia and contract and seat, I've been thinking on what on what Sherlyn said at the beginning. And it's true that some companies, especially those companies who are controlled in Latin America by companies coming from Europe perhaps, or United States, who geopolitically see China as an antagonist, may have these fears. But these are, as Sherlyn said, political fears that are not based on perhaps objective elements. But besides those companies, I have the impression, and it's my feeling being here in Mexico, but I think it's also the case in other Latin American countries in the same situation, is that for Mexico, the fact that China has been politically controlling a bit more, Hong Kong doesn't change things. We have been used to litigating or arbitrating in the United States for a long time. It's expensive, we don't have a choice. And China has become now one of our perhaps more attractive partners. So being in Hong Kong with arbitration, for most of the lawyers who are in the community of, dealings and arbitration, it's still very good. It's still better than going to courts in China or going to arbitration in China because of the language barriers that some times we have faced Mexican companies. So I think we would still appreciate going to Hong Kong instead of mainland.
Yeah, thank you, Edgardo. Yeah, I had the chance to discuss this in a practical matter once with Sherlyn, and that's pretty much my impression that Hong Kong will remain as a very important venue for disputes with Chinese parties, and as it has always been. It may be a different question whether disputes with Asian companies in general, not from China, will also rely on Hong Kong. But since China is such an important business partner for all the world, even if only PRC companies are the ones that still rely on Hong Kong, that's still going to be a huge amount of business. And so, well, I would like to end by turning back to Sherlyn for her comments on what we have been discussing in this dispute resolution section. And then, Sherlyn, if you can turn the floor back to me, I would like to make some final remarks. But please do a comment on what our friends, especially our friends Diana, Fabio, and Eduardo mentioned about the practical reality of dispute resolution negotiations. Please.
I think it's just going to be, it will just be a quick comment. It's really nice to see that arbitration is making its way worldwide, and not just arbitration, the various other aspects of ADR I do have to be honest, though, I am not the biggest fan or supporter of mediation. Although I will say lately that is probably changing because of the Singapore Convention. Whilst I was in-house counsel, we had a huge international dispute where it expanded and ended up in about 25 litigations and arbitrations worldwide. And because the parties were incurring millions of dollars in legal fees, we did go to the drawing board about 2 or 3 times for mediation. And I can say all that did was result in more legal fees, because usually once you get to a certain point in a dispute, mediation probably isn't going to help. Nevertheless, mediation is a good type of this alternative dispute resolution. So it's just very good to see that all of our colleagues here today are really looking at ADR as a good option rather than immediately fighting for the courts. I do also agree that lawyers these days are being asked to spend a lot of time not only to predict the future, and if you can't do it properly, then it is all your fault because the business couldn't proceed because you weren't able to predict the future and you held up the negotiations. But I think that's what we're there for, right? We are there to spend 2 or 3 days negotiating over 1 or 2 terms. In the end, we are able to take a look back and recognize for the next round of negotiations, perhaps we can approach it differently and not spend 2 or 3 days on that one phrase, but we always come to realize that it ends up being a different phrase. But bottom line is increase and rise in ADR options is a very, very good conclusion from what I've seen from today's conversation. And from this, I turn it back to you, Cesar.
Thank you, Shirley. Well, I think I speak for everybody that's been watching us when I say that this has been a remarkable, very rich conversation. It couldn't be well, of course, it would be personally much better, but it couldn't be any better if we had been able to meet in person. As I said in the beginning, it would have been very hard to have such busy professionals as yourselves to get together and have this conversation in any other format. So I think I'd like to thank very much Ingeborg, Edgardo, Renata, Sherlyn, Diana, Fabio, and Eduardo for taking the time to be here with us and discuss such important matters. I've certainly learned a lot today here, and I'm sure all our audience did as well. And I'd like to invite everyone, all of you speakers and everybody that's watching, also to our other virtual cocktails that will take place at the same time tomorrow, Thursday and Friday this week. If you can look up the Vis East website, and all the information will be there. This has been an enormous pleasure to be with you here this morning in Brazil, afternoon in Europe, evening in Hong Kong. And well, thank you again. And with this, I will close our discussions for today and look forward to seeing you all in person again as soon as possible. Thank you. Thank you so much. Okay, bye-bye.
Bye, everyone. Thank you.
Bye-bye. Thank you. Bye-bye.